Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. Wa sallallahu wa sallama ala Sayyidina Muhammad wa ala alihi wa sahbihi wa sallam. We reach now the section on defining Ijma after he's described the why the Ijma is a means of certain knowledge. He says the limits or the definition of the Ijma, which is considered a proof in sacred law, is the consensus of the scholars of the age, whichever age it might be, from people who are known for moral uprightness and ijtihad, we could simply call it legal expertise for now, regarding a legal pronouncement, people who are able to exert themselves to arrive at a legal pronouncement. How does that consensus be established from them? He says, sometimes it might be because they explicitly declare their agreement. So that's what he calls nas. And sometimes, so that's one way, he says, and sometimes, he says, it's by some of them declaring their agreement, whilst others are silent from responding. So the first is your explicit consensus, where they all such scholars declare their agreement. The second is an implicit consensus, where some declare their position and the rest, while being aware of it, are silent. So he's going to go on quite a bit on the second type. And as he explains the second type, there'll be some quite fascinating insights into, I guess you can call it the moral duty of scholars to declare their disagreement. And some very interesting stories and analyses of when silence isn't a problem, when it is a problem from scholars. So there's a good angle on Nahy al-Munkar and the duty of scholars, which is going to go into. So slightly lengthy discussions, but quite, I think, fruitful. So he says the silence, which is a proof, is a silence upon that fatwa being presented to them, the fatwa of some scholars of their age. Either it's formally presented or it is well known. One second. So the fatwa is either formally presented or it's well known amongst people. And there's no manifest opposition to it from anybody. These are the two ways you've arrived at a silent consensus. And why is that a proof? Because if, according to a particular scholar, the correct ruling is opposite to what he's heard, it is not plausible for him. Silence is not an option for him. He no longer is able to be silent and not mention his opinion. He has no moral possibility to stay silent if he disagrees. And so his state, namely the fact that this is an upright moral scholar, a scholar of uprightness, he's not a fasiq, he's not morally corrupt. His state implies that his silence must be a silence which is permissible for him in sacred law. And what's a permissible silence? It's when the ruling, according to him, is the same as in that fatwa. And this is always going to be the implication if he remains silent until a time in which the like of him has had a sufficient opportunity to really reflect on his own opinion regarding that question, to arrive at the correct answer. This is something also I think we've discussed previously, the idea that there is an actual truth that jurists are after. It's not relative, there's not a multiplicity of truths, according to certainly our author and his legal tradition. And so scholars need time to arrive at the truth, to really reflect on what is right. And so that time, everyone is allowed to be silent. But once such a time elapses, when someone should have had enough time to think about a question, then if they're still silent, then it has to show approval. So already you get this idea of a moral duty that the status of scholarship gives people, which is when you hear a question, you have to exert yourself to arrive at an opinion. Do you agree or disagree? You can't just, at least as a scholarly community, pass it over without reflection. And then secondarily, if you are convinced that that common fatwa is wrong, then as a scholarly community, you cannot remain silent. And that's the fundamental duty of scholarship that he's presenting in this chapter. So then he says, so silence itself might be because you're exerting yourself in that moment to find the truth. That's why we need a sort of time period. And he says, it doesn't really matter, this question of ijma or silent ijma or even explicit ijma, how many scholars are available in that time, because the evidences he's presented in the last section showed it's not tied to number, it's simply tied to the fact that the learned of a period have agreed. And there's no consideration given to the fact that they maintain that position until they die. All we need is the fact of agreement. And there's no consideration given to the fact that common people who are not considered specialist scholars have disagreed. You know, common people have no capacity to have an opinion around that topic. Nor is consideration given to those accused of hawa. And hawa here explicitly, as we'll be seeing, is a question of bid'ah, people of a specific inclination which takes them away from the common community or the well-known community, or you could simply say the Sunni community. Their disagreement is not considered in the matter regarding which they have disagreed with us. In that very matter regarding which they were called people of Hawa. So a breakaway sort of community in some matter of belief, if that belief is considered heretical, then their disagreement on that point is not considered, because that's the point on which they have departed from community. But beyond that, their scholarship can be considered if the next point doesn't apply to them. He says, as for their disagreeing with us in other than that point of heresy, then it is considered, because that point of heresy, they could have arrived at it through according to them, a dalil. So outside of that, they are righteous and they are learned. And so their righteousness and their learnedness is still considered. Unless that heresy of theirs is an extreme one that leads to either unbelief, in which case they're not considered part of the Muslim community anymore, or lead to such a lack of morals and scruples and sense that they become boundless, they become illicit in their practices, to the extent that an ordinary court would not accept their testimony. These are people of fisq, of moral corruption. If that's where the heresy leads to them, where in an ordinary court they would no longer be capable witnesses, then obviously in the court of the scholarly community, they cannot anymore testify to truth. So outside of this, the people of all people of bid'ah, the assumption is that their bid'ah has been arrived at through some exertion of scholarly effort. We consider them wrong, we consider them erroneous, we consider them sinful for not considering the topic carefully. However, we do not take away from them their status as pious scholars outside of the point of the heresy. So that's all he emphasizes there. And he'll give some examples of this in a bit. He goes, as for the explicit ijma, where everyone states their opinion, and there's no issues for us to be discussing there really. As for the silent ijma, then let's discuss why it works. It's because the listener is not allowed to stay silent from clarifying the truth. Again, this whole theory is going back to this idea that there is a thing called the truth in matters of the law that scholars are tasked to discover and stand by. If his knowledge, again, this is also, these are all strong terms. as far as this person's belief of what is correct in knowledge, a sort of, we could call it conviction, that this is what the matter really is. If his knowledge, and this is important as will come later, if his conviction of what the matter really is on the opposite of what he's heard in this fatwa, then his status of adala, of being morally upright, which is a status that in sacred law was given to ordinary people as well by courts. The whole court system in the sacred law, the whole social justice system within the sacred law, where communities can arrive at ways to resolve the disputes, all of it was centered on the fact that there was an objective status for moral uprightness called adala, which judges could possibly and positively verify. And so it is not a vague statement, it was a well-known social standard that was verifiable by court proceedings. And so this is what the status is what's being required here. So the fact that someone has this status of adala, it must imply that his silence is a silence which is halal for him. And that's a silence where the thing which he's heard is truth, according to him. Otherwise, we have stipulated, if that's not the case, a time period for the person to reflect and discover the truth on that matter. Because the truth, you don't arrive at it through the exertion of effort, except after reflection in similar cases, and then separating what is most similar from the rest of those similar cases. And this must need time. This procedure, which is described here, really is the essence of fiqh. It's the essence of fiqh for the mujtahid, but also for the mufti. It's about reflection in the rest of the law. That's all that qiyas is, as he'll be describing himself later on in this book at some length. And then really pondering on the logic of all the similar cases, and then arriving at the most similar case. And at that point, your ijtihad, your exertion of effort is complete. So this process will come to in great detail later on. But that's the essence of ijtihad in all time and place. He says, then the time period for the like of this procedure, as has been ordinarily observed, does not last until death, rather just until a time when the correct angle to look at the question has become clear. Either he will agree, or she, I'll stick to he as the standard pronoun, either the scholar will agree, in which case there's no moral duty to speak up, in which case the silence is a sufficient sign of proof. There's no moral duty to stamp approval. Or there'll be disagreement, in which case he must respond. Or a third possibility is that the similar cases, there's no one case which stands out. When he sees the truth, he says, well, it could be this way and it could be that way. At this case, still the scholar has a moral duty not to be beyond the fence, because again, there is a truth which scholars are after. And so in this case, it's very, very similar. And so what he says, the moral duty then is still to give a fatwa with one of these. That's his duty at this case, to give a fatwa with one of these similar cases, one of these angles to look at the question. So his silence is still considered a fatwa in accordance with the original fatwa, if he stays silent. And he's allowed to do that because that's one possible fatwa for him. And if he wishes an alternative fatwa, then he should speak. So real emphasis on this particular moral duty, and he's going to go on as well. So he says, okay, but someone might then ask, an expert scholar might appear to such a person later in life an alternative position. He might come back on his original position. So why don't you stipulate for the validity of a consensus that all members remain upon that position until they die? We respond to this objection that once it's become established that the truth will not be found outside of their consensus. And that's what he established in his last lengthy exposition. Once we know that fact, then we know for sure, after their consensus has been realized, that they have discovered the truth, the very truth. And once we know that, then it's not possible, based on the evidence of the last section, that any of them, or certainly not that the group of them, could go against truth. Just like it cannot be conceived that this community would go against the book of Allah subhanahu wa ta'ala. So once truth is realized, truth is realized. And you might object, sometimes silence can be out of fear or awe. For Ibn Abbas once was asked, may God have mercy on him, about his proof for the for I think it's rejecting the awl in inheritance. So the awl in inheritance is when the fixed shares of inheritors do not reach the full perfect share, do not reach 100%. And there are no, what some people call universal inheritors or asaba to take the rest. Then scholars say, then whatever remains, we'll divide it over the inheritors. We'll give them more than their fixed share. That's called the awl. And so it appears that Ibn Abbas didn't accept this position. And so he mentioned his proof for his position. And then he was asked, why didn't you say this to Umar, who judged in favor of this? And Ibn Abbas said, well, out of fear of him or awe for him. So here's a story or a report. And what's going to happen is he's going to engage with rejecting this report from a number of angles. And the angles he's going to take are the angles which he himself will be explaining in some length in the section on hadiths and reports. Namely that if a hadith comes from the Prophet ﷺ, but we don't know that the well-known scholars of law from the Salaf practiced it, then that hadith is not particularly strong. And such a hadith will only be followed if it has some other testimony to its truth, either the fact that it agrees to the Quran, certainly, and also that it agrees to the qiyas. Secondly, you can see these are the two witnesses almost, if there's no Salaf acceptance. And if the Salaf practice is to the contrary, the hadith has to be rejected. So that's a basic method he'll be saying in the hadith theory below, and he'll apply this method here, that this report goes against what is well known from Ibn Abbas and what is the qiyas of how we know the scholars to be. And then he gives a ta'wil if its report happens to be true. And in the ta'wil, he also gives some interesting insights to the moral nature of this question of silence. So he says, we respond, this is not correct according to us, because Umar used to prefer him over many of the companions and ask him and praise him and deem his effort, his ijtihad, seemly. Other reports clash against this. And other instances show that Ibn Abbas did respond to questions in Umar's time. So again, so this lone report is against other well-known reports. And if it happens to be established, then this awe, let's then theorize, what's the nature of this awe? It's because Umar is superior to him in deen and fiqh and ra'i, due to his vast experience in this matter and great standing amongst the Muslims in these matters. And so all that must have occurred is that this recognition from him of the status of Umar prevented him from extending himself in debate, not the fact that he was silent in simply stating his position. Rather, such a sense would prevent him from extended debate, because Umar was soft before the truth more than others. I am more willing to accept truth than others. And he used to urge people to be like him, he himself was, to instantly speak out. He used to say, there's no good in you if you don't speak, and there's no good in me if I don't listen. And he used to say, may God have mercy on a man who gives to his brother his faults. And he was the most of all the companions in consultation. So he's saying this, the wider set of reports goes against this idea that Ibn Abbas was too scared to speak the truth. This just simply doesn't fit the wider set of reports. Yes, maybe he doesn't feel it's his place to argue extensively, but that's not what our topic is about. And he says, and is it possible? So he says now an interesting nuance. He says, well, it's permissible according to us that there are two scholars who disagree on a question, but one of them is earlier, i.e. in fiqh and learning, greater in fiqh. And so the one who is beneath him in standing defers to him, to the one who is above him in standing. Why? Because he accuses or belittles his own opinion. And so he doesn't respond to him the response of somebody who is munkir. Because ijtihad, at times you don't feel, you feel this is the best I can do. And so we've said you have to state that fatwa. But if the opposing party is someone that you feel is greater in ijtihad, we'll be seeing later that this has an epistemological status and a system that our author is going to be representing. That's why the fatwas of the Salaf are given such weight, because they're considered people whose fatwas are stronger than anyone who comes after them. So that itself is a sort of dalil in the law, the fatwa of the more learned. And so this is not a moral failing to let go of extensive argument. So he's saying a radd of inkar is what he's looking for. And a radd of inkar is not morally binding in a case where you are belittling yourself before someone who is, in your estimation, superior to you. And this has epistemological basis, as he will argue later in this book. So that's a bit of nuance. He's going to develop this a bit further. If it is said, didn't Umar consult the companions about money that is left over from the Muslims, i.e. from forms of public revenue? Money is left over in the Bayt al-Mal. Should we keep it or should we spend it? And so they all indicated to him, you should keep it in the Bayt al-Mal until a time of need comes up. And Ali was silent amongst people. So Umar asked Ali, and Ali said, people have spoken. And Umar says, I swear you also must speak. And Ali said, well, I think you should divide the money. And then he narrated a hadith from the Prophet ﷺ. I spend the money, don't keep it in the Bayt al-Mal. And he even related a hadith on this matter. And so we see from this incident that Ali did allow himself to be silent, even though the ruling according to him was not what they judged. So now he'll analyze the nuance of this incident. He says, we'll say in response that Ali, God have mercy on him, allowed himself to be silent because that which the people indicated to Umar of holding on to the money until the time of need was, according to him, a good position. It was allowed. It just wasn't his preferred position. So his silence was meaningful, that yes, this is a good position. But when he was asked to speak, he spoke with an alternative position. This next sentence has confused me slightly. He says, and what we get out of this stance from Ali is extreme caution in الاحتياط للخروج عن الأمانة وهو الأحسن. So I think my best reading right now for this phrase is, when Ali spoke, when asked to speak, then he did this because of the amana. When somebody asks you your opinion, then there's a trust they've given you to give them what you feel is the best advice. So out of fulfilling that trust that has been cast on him, for the duty of fulfilling that trust, then he stated his contrary opinion. And that's the best thing to do. But the opinion itself was good according to him. And that's why he didn't feel any moral duty to speak. And that's why speaking in such a case is not necessary, but it is good. And so you are allowed to be silent in such cases. And so this section, this chapter is really brilliant about the nuance behind the duties of scholars. And so I think there's a lot to reflect upon. It's not the case you have to instantly shoot in opposition to everything that you hear, but you do have a moral duty to community. And so there is nuance here in this section. And so his state shows that what was mentioned in the gathering was good, according to him, was acceptable. But we should state and be clear that the very fact of his silence, that does not mean that he supported the position completely, because it is because silence is always allowed while you're thinking about what people have said, and to test their understandings until the time passes, i.e. either the time for that gathering to reach a conclusion. Until such a time, silence is appropriate because you're thinking and you're trying to see how people are arguing their case. So silence itself is not a proof at that moment. So nothing in that story, if the story is true, is correct in its transmission, nothing in that story shows that Ali agreed. May Allah have mercy on him. All it shows is that he was silent in the gathering, and silence in a gathering during a debate is obviously fine. So quite a few angles in that story. Then he says, and we don't give consideration to the disagreement of the general public because they don't have insight to these matters. Just like we don't give consideration to people who have no morality, who have no moral bounds. And he'll talk a bit more about that. There is no consideration to those whose testimony is not acceptable in this worldly matters. If their testimony is rejected because we are accusing them of lying due to fisq, again, this immorality, no moral public, they defy public moral standards. And so the courts don't accept their testimony. Someone like that can never be accepted to testify in matters of religion, because the matter of religion is more serious than the matter of this worldliness. And so this accusation has led to the rejection of their testimony in this world, and so it must lead to rejection of their testimony in matters of the religion. But there are sometimes testimonies rejected not because of an accusation of fisq. For example, it could be a testimony is rejected in a worldly court because somebody is the father of someone, in a dispute. So in a worldly court, we'll reject the testimony because of the close relation. So this is not such a reason will not obviously affect someone's contributing to ijma. Or you might in a worldly court reject a witness not because of fisq, but because of some sort of established hatred to one of the two parties in court. So there's a fear of bias. Fear of bias is not considered in matters of ijtihad. This is not a conceivable accusation, because we're discussing opinions here and not people. We're discussing manifesting the ahkam of Allah. And so these last two matters obviously don't count. But if a court rejects someone for fisq, then they'll be rejected in ijtihad. As for now, he's going to go back in. So he's going back into these earlier conditions. As for the person of a hawa, of a heresy, we don't consider their opposition in the very matter to which we ascribe them to heresy, because we only ascribe them to heresy because they went against the general group. We only ascribe that person to hawa because he went against that position which he was morally bound to give a fatwa by. because that position had a dalil that leads to ilm, that leads to certain knowledge. So they went against the dalil that we felt leads to certain knowledge. And that's why we ascribe them to Hawa, that they were overcome. Because Hawa, we said right when the book started, the first chapter was about Hawa. Hawa, this sort of lust, caprice, overcame their sound judgment on this question. Otherwise, the proof was exceedingly clear to the scholarly community. But their sort of preconceived caprice overcame their judgment. And that's why we, the community, ascribed them to Hawa. And so in that point, they're considered biased. And so that opposition shows that their opinion is not considered. There's too much bias. يصير خلاف ذلك دليل برأيه ساقط عن كفافه نصا. Anyway, I'm in this current moment I have to analyze the but all he's saying is that opposition to that opinion through his own ra'i, that disagreement falls. It has no consideration. Just like if he goes against an explicit text that is narrated to him. And so that's why we judge that he's a person of Hawa. As for an other than that of the rulings, then if his heresy leads to a lack of all moral standards in this sort of path that he's taken, Nihla, I saw one of its meanings was al-iddia bil-batil. So if I just follow that one for now, his false path, if you like, that he's taken for himself, if it leads to this lack of moral standards against all other evidence presented to him, out of, again, a sort of mindless, biased, principleless, holding on to his own opinion without any proof, or because he's unwilling to consider, then this person, his opposition will not count. But if all of this is because of a particular shubha, its particular interpretation, then this is still acceptable, as he'll say. And that's why such people, you cannot accept their worldly testimony. If such a person goes so far in this hawa until he reaches unbelief, then obviously the ijma we care about is the ijma of Muslims. And so now, after giving that explanation, that's why we don't listen to the Rawafid when they disagree with us on the Imam of Abu Bakr as-Siddiq. For us, the Imamah has been established through clear proof, which is the agreement of the community of that time and all of its learned people to the validity of this Imamah of Abu Bakr as-Siddiq. And they fought with the Siddiq in his battles. And so when a group says this was not a valid Imamah, they're rejecting what is clear proof. So on this point, their disagreement does not violate consensus. And similarly, the Khawarij, when they say there was no validity to the Imamah of Ali radiallahu anhu, also this is rejected because they're violating what is clear, what was clear from the followers of Sayyidina Ali. But we don't call them unbelievers because there is a shubha, there's a sort of evidence that they're holding on to. So it's not considered absolute violation of consensus, because consensus leads to certain knowledge. And all that we say regarding them, so he's going back now to describing this silence again. This silence, which is a proof, sometimes it is silence when the fatwa is presented, we said, and that's evident. And sometimes it's when you don't express opposition, when the fatwa is well known amongst people. Because the fatwa of some scholars, when it's well known amongst the general public, it is not ever, it's not conceivable that would be hidden from their peers who are the specialists in these matters ordinarily. And so being well known is like being presented to them. And so responding to it is incumbent on the listener if the truth according to him is other than what has become well known, just like if the fatwa was presented to him explicitly, what do you think? So just as much as the moral duty to respond when you asked, what do you think? The moral duty stays when the fatwa becomes well known in the public. And so he must oppose it. Wherever the first fatwa went, he must oppose it there, wherever it became well known. Just like a verse, if it abrogates an earlier verse, it is incumbent on the Rasul to tell everyone about the abrogating verse wherever the first verse has gone, has reached. And so if it's incumbent to respond to a well-known fatwa with as widespread a manner as the first fatwa spread, it is not permissible for one to be well known without the other one being there. And this idea that when a thing becomes well known, then the response must also become well known. This is a basis in kalam, because in the kalam argument for the truth of the messenger through the miracle of the Quran, that argument is based on this premise. It's saying the Quran is a miracle because the Arabs were unable to oppose it. And this inability, we cannot establish it exactly. We don't know what happened inside people's homes, but we only establish it through this very same method, that if it didn't become well known in public, that's how we make the case for the miracle of the Quran, because it is not valid. Does not occur ordinarily that that something like the Quran, if somebody did produce something like the Quran, it would just vanish to nothing, and it would leave no trace behind amongst people. This is not conceivable ordinarily. After coming into existence, when you consider that those who denied the Quran were more than those who believed in it, and they needed this response with something that was like of it. And they wouldn't be able to respond except by narrating this thing that's like the Quran. Just like the believers needed to narrate the Quran to prove it. So the Quran was spread amongst people because that's what the believers believed. And the people who were greater than them in number, if they felt something was like it, they would have narrated it to a similar extent to respond to the Quran wherever it's reached. And that definitely did not happen. And so it's an identical argument then to the argument for silent ijma. So it's a very strong argument to say that silent ijma is a proof within this system, certainly, of legal theory and of kalam. If it is said, muzara'a, which is a sort of sharecropping agreement, some people bring seed, some people bring effort, and then they share the fruit. In the qiyas, this should not be allowed because you are paying people with something that doesn't yet exist in the world, namely the fruit of their efforts. And so Abu Hanifa didn't consider this contract permissible. So he says, if you say that Muzara'a was well known amongst people after Abu Hanifa, and there's no public opposition because it became a well-known practice, then why don't you consider this ijma? That there's an ijma of scholars that Abu Hanifa has violated in saying that this is not allowed. Why isn't this ijma? So he's, again, a very interesting nuance to this question of silence. He says, first of all, the rad was well known. The that muzara'a is not valid was well known amongst the Shia of Abu Hanifa. A very interesting phrase I've never seen before. The Shia of Abu Hanifa, the people who stick to Abu Hanifa's opinion. Because Abu Hanifa's students, at least Abu Muhammad and Abu Yusuf, they felt this contract was valid because it was well known. But he's saying, no, the camp of Abu Hanifa, which would mean not Abu Yusuf and Muhammad at least, they were responding to the invalidity of muzara'a in these times, in fatwas and in debates. But the general public practiced the opinions of others, that's all. It's not a case of ijma of the scholarly community. And according to those who don't allow muzara'a, it's fine for people to follow those who go against Abu Hanifa, because they believe that that other position is strong, because that's what scholarly disagreement is. Although I might be from the Shia of Abu Hanifa, I understand that some scholars believe another position is stronger, so I don't consider it immoral and incorrect for the general public to follow these other scholars. And so the fact that something is widespread practice does not mean it's a case of ijma. So my being silent from calling the general public astray and really being harsh against the general public does not mean I agree with this opinion and that this opinion is truth, contrary to what Abu Hanifa has held. It does not mean that. And rather, I continued in scholarly gatherings to say Abu Hanifa's fatwa is correct. So there's no ijma. And this is just the case where if a mufti hears of the qada of a qadi opposite to his own opinion and stays silent, his silence does not mean that he has now followed the opinion of the qadi. Because even though it's against his own opinion, he still believes that the judgment of a qadi is valid and goes through, even when it's against his own opinion, because that's what the qadi's position is. The qadi's position is to give legal weight to a position. And so although that's not my preferred position, the qadi's judgment is still valid according to me. I don't have to speak out against it. His judgment, his position made it valid. So we'll stop there. We've got one last discussion of ijma, and these are the last of his the proofs that give certain knowledge about types of ijma. But this section, I found it very educative, very informing about scholarship. So I do think there's a lot for us all to reflect upon in today's discussion. وجزاكم الله خيرا وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم الحمد لله رب العالمين والسلام عليكم ورحمة الله.